Article 19 to 22 contains the right to freedom. Right to freedom is considered as the heart of the Indian Constitution as it gives the basic and vital rights to the citizens of the India. So what is considered as the heart of the Indian Constitution? The heart of the Indian Constitution is the right to freedom. But even this right is getting suspended during national emergency. Article 19(1) is related to provides that all the citizens, so we have all the citizens, this right is applicable only to the citizens. All the citizens shall have the right is for the freedom of speech and expression. First you are going to speak, a person speaks, right? Few people they gather and they listen to the speech. So right to the freedom of speech and expression, this is going to be assemble peacefully. They are assembling peacefully without arms. Here without arms, assemble without arms. Then he just convinced these persons to join his association. So they are forming an association and or a union, or even this includes cooperative societies. They are forming an association, union or cooperatives, right? Then they start moving. So this is 1, 2, 3, 4. They start moving. At some place they are residing, right? And in that place they are doing their work. So profession. Freedom of speech and expression, assembling peacefully without the arms. Then they are forming, this entire thing is forming an association, your union or cooperatives. They move freely throughout the territory of the India and they are residing, right? They are being stationary in some place and then they are having freedom for profession. Everything is under Article 19(1). 19(1)(a), 19(1)(a), 1(b). This is assemble as 1(b), 1(c), 1(d), and then 1(e) is related to, we'll be having property, right to property, which is repealed. E is related to the right to property and then it is repealed by 77th Constitutional Amendment Act. So this is F. Right to move freely throughout the territory of India is C, and right to reside or settle in any part of the territory of the India is G. E is repealed. The right to acquire, hold and dispose the property. Now this right is going to, you are acquiring a property, you hold it or you are disposing the property after some time. Acquire, hold or dispose the property. So we have the right to acquire, hold or dispose the property. Acquire, hold and dispose the property. This is being repealed, right? And then we have the right to practice any profession or to carry on any occupation, trade or businesses. The right to practice, we are practicing any profession. So the right to practice any profession or to carry on. We have to carry on any occupation. So we have to carry on any occupation. We'll be having the trade or we also have the businesses. Trade or the business, right? Now, these rights are protected only against the state action and not against the private individuals, and available only to the citizens and to the shareholders of a company, but not the foreigners or legal persons. This is not even available for legal persons or foreigners. It is available only to the citizens and the shareholders of a company. Freedom to acquire, hold and dispose the property. So we are going to acquire a property and then you are going to hold the property. If you are liking it, you are going to hold the property. Otherwise, you are going to dispose the property. Acquire, hold, and dispose the property was deleted by the 44th Constitutional Amendment Act of 1978. Now, freedom of speech and expression, Supreme Court implies the following: right to propagate one's views as well as the views of the others. You can speak about your own view, or you can speak about the views of the others as well. You can propagate the views of the others as well. This is how people even propagate the Gandhi's ideologies, right? Example for this: freedom of the press is under Article 19, freedom of speech and expression, right against tapping of the telephonic conversation. This is freedom of speech and expression. You cannot tap the telephonic conversation. Telephonic conversation. So you cannot tap the telephonic conversation. And right against Bandh, called by the political parties. Right. So when there is a Bandh, right is against the Bandh. So Bandh is not a Bandh is not a fundamental right. You have right to move against the bandh which is called by the political parties. Freedom of silence comes under Article 19(1)(a), speech and expression. Right against one is Article 19(1). You have D. You can move irrespective of a bandh, and you can even practice your profession irrespective of a bandh. And right against imposition of pre-censorship on the newspaper. Pre-censorship of the newspaper is Article 19(1)(a), and right to demonstration or picketing but not the right to strike. You have the right to demonstrate or picketing, but there is no right to strike, and there is no right for bandh. This is a right against the bandh for profession and carrying the trade business, and you do not have a right to strike. The reasonable restrictions are mentioned in 19(2). For Article 19(1)(a), we will be having the reasonable restrictions are mentioned under the Article 19(2). Sovereignty and integrity of India. Right. Security of the state. Friendly relations with the foreign states. Public order, decency or morality. Contempt of the court. Defamation, incitement of an offense. First is India. With respect to India, first we need to protect the independency nature of India and its integrity. So sovereignty and integrity of India. Security of the state is very, very important. As well as we need to protect the security of the state. We should have a friendly relation with the foreign states. Right. So there is a friendly relation. This friendly relation is with the foreign state. This friendly relation needs to be protected. Public order, decency or morality must be maintained, and contempt of the court, defamation, and then we have the incitement of an offense. Right. Even the contempt of the court needs to be valued when we are exercising Article 19(1)(a), that is freedom of speech and expression. Now, here defamation is also here, and incitement of the offences. Now, the Supreme Court on the freedom of speech and expression. No additional restrictions other than those which are permissible under Article 19. Other than those which are mentioned in Article 19 should not apply, because Article 19 is the restrictions which has been mentioned in the Indian 19(2) is the restrictions which has been mentioned in the Indian Constitution itself. Can be imposed on free speech of the public functionary. Fundamental rights under Article 19 and 21 can be enforced even against persons other than the states or its instrumentalities. Expanding its scope, for example, Supreme Court in the Tata Press versus MTNL 1995 case declared that the right to commercial speech or advertisement is a part of, so the advertisement or commercial speech. So commercial speech is a part of fundamental right. This is a Supreme Court case where we be having the commercial speech. This can become a MCQ, commercial speech or advertisement, ad. So commercial speech or the ad. Now here we be having the commercial speech or the ad is a part of. We can say that this is the part of the fundamental right to freedom of speech and expression. Now for speech and expression we are having a big list of restrictions. First is the sovereignty. India must be protected at its any cost, right? Sovereignty, integrity, security. This is related to India. So related to India, we be having the sovereignty, integrity, and then we have the security. Next, foreign nations, friendly relations with the foreign states must be protected. The public order, morality, decency. Public order, decent. You have to be decent, and then you also have the morality. So public order, decency, and then we have the morality, right? Then security. First is the sovereignty, integrity, and then we have the security, right? So sovereignty, integrity, and security of India with respect to India. Next, the foreign state. Next, our society. It needs public order, decency, morality. Next, we'll be having the contempt of the court. Then individually, we have defamation and incitement of an offense. Individually, how from India, the nationwide level to the foreign, protecting the foreign nations friendly relations. So step by step we can decode the restrictions under article 19.2, because for remaining articles we have different restrictions in case of fundamental rights. Freedom, right to freedom, right? First is India level. At the India level we say that we have the sovereignty, and then we have the integrity and security at the India level. For the foreign nation, we are going to have friendly relations with the foreign nation, right? So the friendly relations with the foreign nations and foreigners, friendly relation with the foreign nations. Next, we have the public order. For public order, we have to go for the public order decency. So the public order decency, then we are going for the morality. So for the public order, we have to go for the public order, decency, and then we have the morality, right? Order, decency, morality for the court, and for the individual, we have defamation and incitement of offences. Now, over here, the Supreme Court expanding this. Now, these are the Supreme Court interpretation on the freedom of speech and expression, Article 19(1)(a). No additional restrictions can be added apart from the restrictions which are provided on Article 19(2) of the Constitution. Now, the fundamental rights are under Article 19 to 21 can be enforced even against a person. Article 19 and 21 can be enforced not only by against the state, but it can be enforced even against a person other than the states or its instrumentalities. So this is very important, right? It can be enforced even against a person. So the fundamental right against Article 19, and then under the fundamental rights, the two fundamental rights which can be imposed against persons, enforced against the persons, are Article 19, 25. We also have 21. We also have Article 17 also imposed against persons. Now, expanding the scope in the sense speech. Commercial speech in the advertisement is a part of the fundamental right to freedom of speech and expression. These are the points. No additional restrictions. These Article 19 and 21 can be enforced even against the persons. Now, commercial speech or advertisement is a fundamental right to freedom of speech and expression. Then we have the freedom of assembly. We have the assembly. Right to hold public meetings. We are holding the public meetings, demonstrations, and take out the processions. Right. So we are meeting the public meetings. We are going for processions and demonstrations. Public meetings, processions, and demonstrations. It can be exercised only on the public land. Now you can assemble only on the public land. Now what is assemble? You are holding a meeting, right? So this meeting is a public meeting. When you are holding public meeting on a public land, only on a public land, or you are going for demonstration, you are taking march, take out processions, right? You are walking out somewhere. So demonstrations or processions. Here we have assemble, public meeting. There is a meeting, demonstration, procession. Only on the public land, peaceful and unarmed. It does not include right to state, and we have right against the band. Right is against the band. But it is going to include, we have seen here that it includes picketing and demonstration. So it is going to include the picketing and demonstration. It includes the picketing, first one, and demonstration. But it does not include here strike. It does not include the strike. It must be peaceful and unarmed. So you are going for a public meeting, right? You are having a meeting and you are demonstrating something. And you take out in the procession. Now you can also picket. Strike and band is not included. Section 14 of CRPC. Magistrate can restrain an assembly, meeting or procession if there is a risk of obstruction to human life, health or safety or disturbance of the public tranquility. The magistrate, he can cancel or he can restrain, right? This is section 144 or CRPC. 144 is the magistrate. Section 144. The magistrate is going to restraining the assembly. He is going to restrain the assembly. Right. And then we have the meeting. He is restraining the assembly, meeting, and then we have the procession. So he is restraining the assembly, meeting, or we have the procession if there is a risk of obstruction to the human life, health, or even safety or disturbance of the public tranquility. Now, section 141 is assembly of 5 or more people can become unlawful if object is to resist the execution of any law or legal processes, forcibly occupy the property of some person, right? Now, next thing is you are associating. Associations in the sense the right to form a political party, right? And you also have the right not to form. You can even resist forming a political party, company, partnership, film, society, clubs, organizations, trade unions of anybody, It covers negative right to not to form or join an association. You are not forming and you are even not joining. This is 19(1)(c). Reasonable restrictions are when an association is a terrorist association, right? So it affects the sovereignty and integrity. Also the public order, this association, public order, morality. These are the reasonable restrictions. If it is a terrorist organization, it is going to affect the sovereignty and integrity. Therefore, it should not be formed. Such an association must not be formed. It affects the sovereignty and integrity, even the public and morality. Right to obtain recognition of the association is not a fundamental right. We don't need to recognize your association because it is not a fundamental right. Right to freedom of movement. Movement is when you are moving internally versus you are moving externally. Both Article 19 and 21 are available, are enforced even against persons, right? They are enforced even against the persons. Now, it has two dimensions. First is the internal right to move inside a country, and the second one is going to be the external. So, when freedom of movement is having two dimensions, the first one is internal movement. When you are moving inside a country, that is where Article 19 is going to apply. But when you are moving to some other country, we say that external movement, right? When external movement, Article 21 applies. These rights are even enforced against the persons. The reasonable restrictions are when you are moving the interest of general public, protection of the interest of the scheduled tribes, right? The interest of the public and protection of the scheduled tribes. The same almost applies for the residents. Reasonable restrictions. The interest, first you are moving, if there is a, your movement is causing for the general public. Public is only going to be affected because when you are moving. And protection of the interest of the scheduled tribes, not the scheduled caste, it is only the scheduled tribes. Now we have the freedom of residence. You can reside anywhere except the rights of outsiders to reside and settle in the tribal areas. Tribal areas is restricted to protect the distinctive culture and customs of the scheduled tribes and to safeguard the traditional occasion and the properties. Traditional occasion is the job and the properties against exploitation. You cannot reside in tribal areas. This is to protect their culture, customs, their properties. Right to resident and right to movement are complementary to each other. Now, freedom of profession. All the citizens have the right to carry on trade or profession occupation provided the trade or occupation is not illegal or immoral. For example, you cannot become a doctor until you professionally complete the doctorate course. Now, illegal, immoral. This is also the limitations is public order. Law does not prevent the state from making the laws related to technical or professional qualifications which are required. So the state can make a law related to the technical or professional qualifications required for practicing the occupation or the trade. The state is not required to justify its monopoly. The state can have monopoly over the profession, can have monopoly. The monopoly is only by the state. The state can have the monopoly. It does not include the right to carry on profession that is immoral, like trafficking or dangerous, like harmful drugs or explosives. Now we have Article 21. 20, 19, 20, 21, 21A, and then we have the 22. These are the rights which are related to the freedom. 19 has been completed. So 20 is going to be protection in respect of conviction for offences. there is a protection in respect of conviction. You are convicted for the offenses, right? What kind of protection is necessary in case you are convicting for an offense? Arbitrary and excessive punishment of the accused, whether he is a citizen or a foreigner or a legal person like a company. You cannot excessively punish a person. For example, a person has been found stealing food. Stealing food. You cannot give him 5 years imprisonment for stealing food. You cannot go for arbitrary. There is a protection against arbitrary and excessive punishment. So you should not do arbitrarily. And you should not do it also excessively. Arbitrary, and then we have the excessive punishment. So we use a term here called the excessive punishment. When we are punishing excessively. Right. Now, here, this is applicable to citizen, foreigner, legal person like a company or a corporation. No ex post facto law. Ex post facto law. Right. No person shall be convicted for any offense except for the violation of the law, which is at the time of commission of the act, charged as an offense. When he is committing an offense, at that time period, the law must be present. He has committed an offense, but after some time the law comes into force. He cannot be punished for a law, such a law, right? So he can be punished only for the violation of a law which is existing at the time of his conviction of offense. No person, this is what no ex post facto law. So ex post facto law. This is like no ex post facto law. No person shall be convicted of any offence except of the violation of a law which is in force at the time of the commission of the act, charged as an offence, not subject to the greater penalty than that which might have been inflicted under the law in force at the time of the commission of the offence. No double jeopardy. Double jeopardy in the sense he should not be punished for the same offense more than once. So no ex post facto law. And then we have no double jeopardy. You cannot be convicted twice for the same offense. Then we be having that no self. Third one is going to be like no self incrimination. You cannot be compelled to be a witness against yourself. So no ex post facto law and no double jeopardy, and then we have no self incrimination. You cannot be forced to witness against yourself, against oneself, right? So witness against oneself is what we have the self-incrimination. A civil liability or a tax is imposed retrospectively. Prospective is only from the present. A law is on the present on the date of implication. Retrospective. Retrospective is when a law which is implemented today, it is applicable to the past days. Retrospective versus prospective. Civil liability, civil things, and then we have the tax. For example, now if they are having an inheritance law, if they are bringing an inheritance law equally among all the children, it applies to properties which are purchased previously as well. So civil liability and tax can be imposed retrospectively. Protection under the provision cannot be claimed in case of preventive detention or demanding security from a person. This is not applicable. Article 20 is not applicable in case of detention. Article 22, right? In case of preventive detention and you are demanding security from a person. Protection against double jeopardy is not available in proceedings before departmental or administrative authorities as they are not of judicial nature. For example, a person has committed a crime. For that crime, he went to jail. Therefore, his office can also terminate him because he has made a heinous crime. Right? So, there is no double jeopardy. Double jeopardy is not available in proceedings before the departmental or administrative authorities as they are not of judicial nature. Protection against Protection against self-incrimination extends to both the oral evidence as well as documentary evidence. Self-incrimination, you cannot video record me with the oral evidence or you cannot take a written documentary evidence from me. So this protection against self-incrimination, double jeopardy